नुकसान हो चुका है 30 जून 2022 तक and counting.
Basically, you are saying as a consequence of the actions of the Supreme Court in exercise of 184 jurisdiction. Is this the point you're making?
Yes. और उसका review 2006 में
I don't know why we are so reluctant to hear the truth. I mean, let us.
2006 में उसका review file हुआ. 2006 में review file हुआ उस judgment का.
आप बढ़ते रहिए चलें.
This should not be against the Supreme Court.
It's not, but it is a fact. 2006 में उसका review file हुआ सर, और वो review 2013 में reject हुआ 7 साल बाद. उस वक्त तक वो कलअदम हो चुका है और उसके बाद एक suo motu भी आ गया. दूसरा इंस्टेंस है रेकोडेक का.
पहले जरा काइंडली इसकी रेलेवेंस बताइए.
इसकी रेलेवेंस सर मैं इन द कॉन्टेक्स्ट ऑफ
कंट्रोवर्सी एंड टू द कॉन्स्टिट्यूशनैलिटी और अदरवाइज ऑफ दिस एक्ट.
मैं आपको सर ये बताने की कोशिश कर रहा हूँ. This is in relation to the exercise, and this is something that necessitated providing for this appeal. Constitutionality.
Were these cases discussed in Parliament? Because you haven't provided us the reports, or is this your personal opinion?
This is something which has happened over the years.
No, it may
this
have
is
happened.
Not
Nobody's going to get into that. The question is, were these cases discussed in Parliament? Were they discussed? Did they form the basis of why this law had to come? Because that's what we are hearing this case.
By referring the cases from the Aminuddin Khan case, वहाँ से लेके तमाम ये नुसरत भुट्टो केस और फिर ये रेकोडेक केस और सुप्रीम कोर्ट बार केस और ये फिर अकामा केस जो है और फिर ये हुदैबिया केस सारे लेके आप हमें ये चार्जशीट करना चाह रहे हैं कि सुप्रीम कोर्ट ने इन तमाम को देखने के जो को कॉम्पिटेंस नहीं थी उसने लॉ बना दिया और अब हम उसे लेजिटिमेट कर दें. You want to invoke us the doctrine of necessity to legitimate this law?
No, sir. No, sir. To the contrary.
I think
मैं अगली बार जरा कंसीड कर लूँ.
Mr. Attorney General, I think हमें थोड़ा सा हौसला रखना चाहिए सुनने के लिए तनकीद. I don't think you use the word charge sheet.
I have not.
You are simply stating a fact, and we should have the patience to hear your submissions. Your submission is, from what you have just commenced by stating, that 184.3 may have done some very good work as well, but 184.3's consequences have also been, I don't want to use the word disastrous, but maybe not so good. So you're just stating that Parliament does not have to mention each and every case, but this is the cumulative understanding. I mean, you don't have to spell out everything. So Aminuddin Khan was not 184.3, etc., but these cases were. So you are just stating a fact, and we should be sort of have the wherewithal to accept it. I mean, we were a council at some stage, and we are judges now, and we are citizens always. So if someone is stating a historical fact to build the argument why 184.3 may have been given a right of appeal, so let us hear him with patience. And if you don't agree with that, by all means, write judgments, whichever you want to, but at least please continue. I mean, otherwise we will be forever. I mean, you didn't do this thing. You are saying we did it, and you're just pointing, showing us the mirror. Fine, no problem to show me a mirror about all the judgments I've passed which are wrong. I have absolutely no problem. I would say thank you. I may learn from it and I won't commit the same error or mistake again. So please proceed.
Mr. Attorney General, the question still remains, which I've already put before you, whether the court did good or whether the court did bad, and beauty may lie in the eye of the beholder, and there may be people who say that was good and that was bad and that was not so good and that was not so bad. And we can carry on ad nauseum. This is not a debating society. We are not sitting here to receive a public lecture from you, sir. You are Attorney General. Kindly tell us what is...
If there was a remedy of appeal.
Sawal sun le.
If there was a remedy of appeal.
What does that have to do with the...
These consequences could have been averted.
Baat to sun le na. What does that have to do with the legislative competence of the...
I have, as I stated, my lord, I have already made submissions to it. I am referring to what yesterday
Justice Hilali... If there is legislative competence, तो बात खत्म हो गई.
जी.
आप हमें ये necessity दे रहे हैं.
ये इसलिए जरूरी है सर कि ये आपके पास अभी not long ago record के ऊपर under 186 you had to come and protect what had happened.
Then the question that my learned colleague has asked you, that becomes relevant. आप हमें बात कीजिए लेजिस्लेटिव कॉम्पिटेंस की।
लेजिस्लेटिव
आप कन्विंस कर कीजिए कि आपके मुताबिक आप कह दें जी वो सब गलत कह रहे हैं, बात खत्म हो गई, आई डोंट हैव टू डू एनीथिंग, onus lies on them. You kindly tell us about legislative competence.
कल जस्टिस हिलाली ने एक कमेंट किया था, एक ऑब्जर्वेशन थी उनकी, उन्होंने कहा कि 184(3) जब एक्सरसाइज
Mr. Attorney General, I've been a counsel more years than I've been a judge. And I would always prefer that judges let me complete my submissions. They may not accept my submissions, hear my submissions, and discard my submissions. But certainly your right of making a submission, I think, otherwise we don't need to give you a notice, we can decide the matter ourselves. So please proceed in your own way.
While concluding,
दो चीजें देख लेते हैं जी। ये तो यहाँ तक everyone agrees that there were certain issues regarding 184 which agitated or which disturbed the executive, the parliament. Fine. Point taken. Second point, the law that you enacted, that law, everyone agrees कि ठीक है, law में कोई ऐसी चीज नहीं है, बाज यहाँ होगी, लेकिन वो law, no one said कि ये law जो है ये किसी तरीके से infringe कर रहा है आपके fundamental rights को as such, directly. असली जो main चीज आपने address करनी है वो है लॉ की आपकी जो लीगल कॉम्पिटेंस है, उस लेजिस्लेटिव कॉम्पिटेंस, आप प्लीज उस पे आ जाएं।
My lord, I'll come to the question that you had raised before.
आप अपने आर्ग्यूमेंट्स करें।
My lord, I have
my question, take it at the end. पहले अपने आर्ग्यूमेंट्स खत्म करें, like the चीफ जस्टिस just said कि भाई पहले उनको तो बोलने दें, आप जो आप बोलना चाहते हैं प्लीज बोल।
बल्कि सारे क्वेश्चन का जवाब आप बाद में दे दें, पहले अपने
आर्ग्यूमेंट्स।
My lord, as far as provisions other than Section 5 are concerned, with regards to practice and procedure, I have submitted that the competence is drawn from Article 191, read with entry 58, and of course together read with 142A. 191 in itself acknowledges, recognizes Parliament's power to make laws with respect to practice and procedure. And the term law used in 191 does not in any manner exclude an act of parliament.
ये जो आप अगर एंट्री 58 को देखें, इसमें एंट्री 58 में आप किस उसमें आ रहे हैं? Within the legislative competence of Majlis Shura?
Yes.
Or relates to the federation?
First part.
Okay, and so your reliance on item 58 is directly dependent upon or flowing from your arguments that 191 confers legislative competence.
Yes.
Okay, point taken.
So this is the conclusion or some of